As we move forward in understanding Arizona's real estate law, it is essential to examine one of the oldest and most fundamental legal doctrines that governs real estate contracts: the Statute of Frauds. This legal principle, which originated in the 17th century England, remains one of the cornerstones of real estate law today. The Statute of Frauds requires certain types of agreements to be in writing and signed by the party to be charged in order to be legally enforceable. In Arizona, this doctrine is codified under Arizona Revised Statutes, Section 44-101, and it plays a vital role in ensuring that real estate transactions are conducted with clarity, legitimacy, and protection for all parties involved. The Statute of Frauds was designed to prevent fraud, deceit, and misunderstanding in contractual relationships. Before written contracts became the norm, oral promises often led to disputes that were difficult to verify or enforce. For example, if a seller verbally promised to convey a parcel of land to a buyer, but later denied the agreement, the buyer would have no legal proof of the transaction. By requiring certain contracts, particularly those involving real property, to be in writing, the law provides tangible evidence of the parties' intentions, the terms of the agreement, and the consent of both sides. In modern Arizona real estate practice, this statute continues to protect buyers, sellers, landlords, tenants, and brokers by ensuring that key agreements are documented and legally binding. Under ARS Section 44-101-6 and Section 44-101-7, the Statute of Frauds specifies that agreements for the sale of real property, leases for more than 1 year, and agreements authorizing an agent or broker to sell or purchase real estate on behalf of another must be in writing and signed by the parties to be enforceable. This means that oral promises to sell, lease, or represent someone in a real estate transaction carry no legal force unless they are properly memorialized in writing. For example, if a landlord verbally agrees to lease an office building to a tenant for 2 years, but later refuses to sign a lease, the tenant cannot enforce the agreement because it violates the Statute of Frauds. Conversely, if a written lease signed by both parties exists, the law presumes the contract's validity. The statute applies broadly across all real estate contracts, including purchase agreements, lease agreements, option contracts, and agency agreements. It also extends to any modification or amendment to such contracts. For instance, if a buyer and seller agree verbally to extend the closing date of a property sale or to modify the purchase price, that modification must also be in writing to be valid. Arizona courts have consistently enforced this rule, emphasizing that written agreements provide certainty and reduce litigation. In Trollope v. Kerner, 1970, the Arizona Supreme Court ruled that oral leases exceeding 1 year are unenforceable under the Statute of Frauds. Even if one party has already taken possession of the property, the court reaffirmed that equitable remedies like partial performance may sometimes apply, but only when there is clear and convincing evidence that the oral agreement existed and was acted upon in reliance. The requirement for a written contract is not merely a formality. It is an essential safeguard that ensures transparency in real estate transactions. A written agreement clearly outlines the property description, purchase price, payment terms, contingencies, and closing conditions. It also helps prevent misunderstandings about key elements of the deal. For example, in a situation where a buyer claims the seller promised to include certain furniture with the home sale, the written purchase contract becomes the definitive source of truth. If the inclusion of furniture is not in writing, the buyer has no legal right to enforce that promise. The Statute of Frauds also protects real estate professionals by defining the scope of their representation. Under ARS Section 44-101-7, any agreement authorizing a real estate broker to sell, purchase, or lease property on behalf of a client must be in writing. This requirement ensures that brokers have formal documentation of their authority and the terms of compensation. Without a written listing agreement or buyer-broker agreement, a licensee cannot lawfully claim a commission. This provision reinforces the professional integrity of the real estate industry by preventing unauthorized representation and false claims of agency. While the Statute of Frauds demands written agreements, Arizona courts recognize limited exceptions based on fairness and equity. One such exception is the doctrine of partial performance, which allows enforcement of an otherwise unenforceable oral agreement if one party has taken significant actions in reliance on the agreement, such as making payments, taking possession, or making valuable improvements to the property. However, these exceptions are narrowly applied. In Owens v. M.E. Shep Limited Partnership, 2008, the Arizona Supreme Court reaffirmed that oral agreements concerning real property are unenforceable unless there is substantial proof of reliance, noting that equitable relief should not undermine the fundamental purpose of the Statute of Frauds. For real estate licensees, understanding and complying with the Statute of Frauds is critical. It not only ensures the legality of contracts, but also fulfills the professional standards required under Commissioner's Rule R4-28-1101, which mandates that licensees exercise reasonable care and skill in all real estate transactions. Preparing or facilitating written agreements is part of this duty. Brokers must also ensure that all documents, including addenda and amendments, are properly executed, stored, and retained under ARS Section 32-215-1.01. Failure to secure written agreements or reliance on oral promises can expose both clients and brokers to unnecessary legal disputes and potential disciplinary action under ARS Section 32-2153A3 for dishonest or negligent conduct. The Statute of Frauds also intersects with the Arizona Constitution, Article 26, which grants licensed real estate professionals the right to draft contracts and documents related to real estate transactions, as long as they are representing one of the parties. This constitutional authority allows brokers and agents to assist clients in preparing legally compliant written agreements that satisfy the Statute of Frauds. However, licensees must always remain within the scope of their representation and must not draft documents for unrepresented parties, as doing so could constitute the unauthorized practice of law. In practice, adherence to the Statute of Frauds fosters trust and accountability among all participants in a transaction. Buyers and sellers can rely on written terms as the final expression of their agreement, and brokers can confidently manage their duties knowing their authority is documented. When every term, promise, and contingency is reduced to writing, the potential for fraud or misunderstanding is minimized. Fulfilling the very intent of the statute's creation review summary. The Arizona Statute of Frauds, codified under ARS Section 44101, requires that certain contracts, including those involving the sale, lease, or agency of real estate, be in writing and signed to be enforceable. The statute was established to prevent fraud, clarify obligations, and provide reliable evidence of agreements. It applies to sales contracts, leases longer than 1 year, and brokerage agreements. Exceptions, such as partial performance, may apply only in rare and well-documented cases. For licensees, compliance with the Statute of Frauds is both a legal and ethical obligation, ensuring that all agreements are valid, enforceable, and transparent. Discussion: why does the Statute of Frauds require written agreements for real estate transactions? Answer: to prevent fraud and ensure that the terms of the transaction are clear, verifiable, and legally enforceable. What types of contracts must be in writing under ARS Section 44101? Answer: agreements for the sale of real property, leases longer than 1 year, and agency agreements authorizing brokers to represent clients. Can an oral real estate agreement ever be enforced in Arizona? Answer: yes, but only under limited exceptions such as partial performance, where one party has relied on the agreement and made significant actions in good faith. Why is a written listing or buyer-broker agreement important for a real estate licensee? Answer: it satisfies the Statute of Frauds and ensures that the licensee's authority and compensation are legally recognized. Closing remarks. The Statute of Frauds is one of the most important doctrines in Arizona real estate law, serving as a safeguard for consumers and professionals alike. By requiring contracts to be in writing, it ensures honesty, transparency, and enforceability in every transaction. For licensees, compliance with this law is not optional. It is a defining feature of professionalism and ethical practice. Written agreements protect everyone involved, reduce misunderstandings, and uphold the trust that sustains Arizona's real estate industry.